one of the things that I have heard a lot of people who are respondents in restraining orders say is they don't have much of a case, it's all hearsay. So today I want to talk to you about hearsay and how that can come into play for your restraining order hearing. My name is Veronica. I'm a domestic violence restraining order hearing defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything that you need to know to win your restraining order hearing. What you need is to understand from start to finish what the judge is looking for, how to point out lies that the other side is telling, how to present your own evidence. You need to know all of that because you could go in there and be 100% right, but if you can't, for example, play your evidence, or you don't know how to point out the lies in the other side's testimony, then it's going to be extremely difficult to win. So anyway, if that is something you're interested in, you can get your free first class in the course via the link down below. So let's jump right in. There's no evidence, it's all hearsay. Famous last words. So when someone says this, in my experience, they mean one of two things. Number one, they mean it is a he said, she said situation. There is no hard evidence. There's no 100% video evidence that shows in HD the respondent being violent toward the petitioner. So they think, okay, well, since it's a he said, she said, then the case will be thrown out. First of all, that's not what hearsay means. Hearsay is an out-of-court statement, so something that somebody said outside of court, offered for the truth of the matter asserted. That means that whatever statement you are saying in court now that the other person said is evidence that it's true. For example, the petitioner says that the respondent says, I'm going to keep beating you until you tell me the truth, okay? And the petitioner is saying that the respondent said this to support the point that the respondent was actually beating the petitioner, right? Another example is a petitioner saying, and I told the respondent, stop hitting me. And the petitioner is offering that to support the idea that the respondent was hitting her, right? Okay, so that's hearsay. He said, she said, that there could be some hearsay included. But when people say he said, she said, usually they mean party A has this story, party B has this other story, and so nobody can tell which one is true, so we'll just throw them both away. And that is not how it works in restraining order hearings. Restraining order hearings, the judge has to only be convinced slightly more than 50% in order to find in favor of one or the other party. And so the petitioner could come in with no actual documents, with no video, with no witnesses, just the petitioner's own testimony. And that is evidence. That is a form of evidence. Testimony is a form of evidence. And the petitioner could say, he hit me on these occasions, and that could be enough if the judge believes the petitioner for the judge to grant the restraining order. Even if the respondent makes a statement, if the judge says, you know what, I don't believe you, respondent, or if the judge says, I believe you, petitioner, slightly more than I believe the respondent, he got a little bit mad, he got a bit mixed up with his facts, so I'm going to find in your favor, then the petitioner wins the restraining order. So the second way that people seem to think that hearsay cannot come into court is when the petitioner indicates that they are planning to use things that the respondent said in court. So for example, threats. I've had people say, well, they're not going to be able to bring that threat that I made to them in because that's hearsay. You can't bring in hearsay. Something could be an out-of-court statement, but you might still be able to talk about it in court, to have testimony about it in court under certain circumstances. One of them, in the case of a threat, is verbal acts. So making a threat is a verbal act, and so that's not hearsay, and you can bring that in as the petitioner, absolutely. There is also admission by a party opponent. I know I hit you, I'm so sorry that I did that, it will never happen again. That's going to come into court too. One thing you should know is that if the other party is saying something in court that you said, if they're quoting you or purportedly quoting you, it is probably coming in. Objecting to that is probably not going to work. The judge doesn't necessarily have to believe that you said that, but it's probably going to come in. The biggest mistakes that you can make are underestimating your opponent and overestimating your own case. And if you do have a restraining order hearing coming up, look, you can continue binge watching YouTube, hoping to find the answers, or get all of them, which is what I give you in the course. Whenever you're learning something new, one of the hardest things to overcome is that you don't know what you don't know. So if you're just trying to learn by doing, you're just sort of trying to muddle through the process by yourself, then there may be things that you miss because you didn't even know that you had to know them. You had no idea that those things were even a thing, right? The courtroom world is different than real life. And if you go in there just thinking you're going to litigate your whole relationship, you probably are not going to win your hearing. And I want to give you the best possible chance at winning. So go get your free first class. You have nothing to lose. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.